Entrepreneurs across Africa are expressing concern on several challenges that arise from deeply congested court systems. They say lengthy delays in filing, going through the motions of a trial and settling cases, plus the skyrocketing costs involved in time, energy, money in settling disputes are crippling the operations. In Kenya, for example, the judiciary says roughly 500,000 cases are pending at the magistrates' court, and roughly a third of those are more than 3 years old. In fact, the total number of pending cases in the country has gone up by about 20% in the 5 years up to June 2022. Now, consider the fact that a single case could take up to $153,000 in 3 years to settle. These disputes have become a very expensive affair in terms of time and money. But some analysts believe it really doesn't have to be like this. Let's explore this in a bit more detail and bring in Diamana Diawara, who's the director of the International Chamber of Commerce and Arbitration and Alternative Dispute Resolution Unit. Thank you very much for your time this evening. So let's start with the perspective here of the sort of cases that the ICC's ADR unit deals with. In 2021, cases from sub-Saharan Africa, they made up less than 7% of the caseload handled by the ICC's arbitration unit. How have things changed since then?
Well, things have evolved quite a lot since 2021. It's interesting to note that there has been an increase in the number of African parties involved in the ICC dispute resolution mechanism through arbitration. And we're now close to 9% of parties coming out of Africa, which are involved in ICC arbitration. This figure of 9% is quite noticeable because if you look at the past 10 years ago, African parties represented only 5% of the caseload of ICC. So we really see as foreign investment continues to grow within the African continent, as commercial parties and merchants are growing in the commerce across Africa, we see that the use of ICC arbitration is increasing, and we're expecting the same to continue in future years.
When you speak to the clients who essentially come to your ADR process, what do they say is a problem? How do they explain the build-up of pending unresolved cases in the region? Is it mostly an operational issue with national level judicial systems just unable to process things rapidly? Or is it part of it due to firms taking cases to courts that cannot handle them?
There are different elements and different factors that are put forward as what basically does not work. But what comes back continuously is the fact that indeed national courts are busy with all sorts of activities that are coming out of society life. So from family disputes to real estate disputes and also commercial disputes. So all of that is already clogging national courts. We cannot ignore the fact that the COVID period for a number of countries has also meant increasing that backlog in front of the national courts. But these are not the only issues that they are encountering. For merchants who are having disputes that need resolution and needs fast resolution, the fact of going through national courts, which means that any decision is subject to a second review by the courts of appeal, and even sometimes a third review in front of Supreme Court, is not an efficient way to resolve disputes when you need to go about your daily business. And that is where arbitration comes in as an efficient solution, because by its nature, arbitration is final and binding, and the decision of the arbitrators will be enforceable in front of the national courts and will not be subject to a revision, provided it does comply with mandatory rules in front of those national courts.
Is this sort of partly a specialization problem? And the comparison I have in mind here is akin to what we have, for example, in Delaware, right? With the American court system, you've got these specialized courts that deal specifically with commercial issues, right? The Court of Chancery, I believe is what it's called, over in Delaware. Might that perhaps help if we set up something comparable in speeding up the pace at which these cases are being resolved?
You're correct that there is an issue of specialization. I mean, if you have a dispute in a complex construction of an infrastructure project, obviously, if you take that to the regular court, the judges will not necessarily be equipped. And even if they are, they will need to be assisted by experts. The length of that resolution process might not be suitable for, again, merchants who are looking to going about their daily business. But beyond specialization, and I should say that arbitration actually allows to select one's arbitrator, the judge, and select that person within industry experts, within specialized lawyers or practitioners who will have a better hands-on knowledge of the dispute resolution of the dispute at stake and the industry at stake. Specialized court might help, but beyond specialization, parties are also coming to arbitration simply sometimes because they're looking for confidentiality, which by nature national courts cannot offer, because the justice system is a public one by nature. So sometimes turning to arbitration means also turning to a system that allows you to protect your industry secrets. For example, it also means for certain parties that they are moving away from a system again where they might be subject to appeal and to also further review of the decision, the first instance decision in front of Supreme Court. So there are a number of reasons why parties would go to arbitration. Even if there are specialized courts, they might still want to turn to international arbitration or local arbitration to resolve their disputes.
One last question for you, and I wonder how you often deal with the clashes in terms of jurisdiction that may occasionally come up in this sort of thing. When clients come to the ICC's ADR system, are the decisions coming out of there formally recognized as a valid alternative as a first step, or have there been incidents where the court say, no, hang on, you jumped the gun by going to the ICC in a completely different territory before coming to us first?
That's a very interesting question. Thank you for that. Nowadays, I mean, we are in a situation across Africa where the basic principle that whenever the parties by their will have chosen arbitration, that choice of the parties, that autonomy of the parties should be respected by national courts. So the state of the law across Africa, in Kenya, in Nigeria, in South Africa, in Congo, is that the choice of arbitration should prevail until the arbitrators themselves would decide that they are not the right forum for the resolution of the dispute. So to answer your question, yes, arbitration is absolutely recognized across Africa as a valid dispute resolution mechanism that courts will enforce, meaning that having made that choice will be respected by the national courts.